But the item 18, affidavit in dusty has been, can it be brought on record? Like.
Really? Mr. Shom? You see, Mr. Counsel, that day I looked into this matter. Your case is you are asking for partition.
Yes.
Their case is he's also asking for partition. He's asking specifically Schedule B land.
Schedule bill and the portion where he constructed the commercial.
He's asking that. But the fact that both the parties are agreeable that there is a requirement of partition. Okay.
That is good.
Now he says that there is a question of me, his specific plea in his suit is that there was an partition, and pursuant to the partition, there was a power of attorney which was given by our father, on the basis of which we had taken a loan of 35 lakhs. Out of that, he had used 14 lakhs and spent in the construction of the building in the front of it, in Schedule B land. And therefore, he said that I have been asking them for partition of this so that this B schedule land is brought outside the Schedule A land. That is some 18 lechas or something.
16 point something less.
On the other hand, you say that there is no such amicable partition to that effect. We also want partition, but this partition should be done which is normally done. This is 2 kata 10 lechas of land. We are all equally entitled to, so have it. Now, if you say Order 18 Rule 3,
No.
Order 18 Rule 3 is a very different provision, which states that a person who has a right to begin can very well say that I give my evidence only to this extent, or I don't give the evidence, let the other side, because both sides want partition. So therefore, let them come up out and prove it, that they are entitled to whatever amount. Or Order 18 Rule 3 will say that I will prove this portion of it, of my evidence, and reserve my right to prove something else, which they are required to prove. And after they prove it, then I will again give lead evidence. So therefore, although there is no much judgment of the Supreme Court on this, there are few judgments of Bombay High Court, which I could lay my hands on. This is a permissible mode by which you can adduce evidence. Now, the fact that it is a joint property is not in dispute.
Not in dispute.
Whether he is entitled to Schedule B land is a thing which can be only decided at the time when the partition is being carried out. Not by the court.
Yes.
By the commissioner under Order 18 Rule, Order 20 Rule 18(2). Because there has to be a preliminary decree saying that this person will be entitled to this much and this much and this much. And accordingly, if there is certain area of land by which is on the front portion, let us assume that Schedule B is on the front portion, and is being given to you, which may have a frontage, which the back portion may not have, then in that case, the question of OLT, all these things will come in. So therefore, both the parties duly agree that there has to be a partition. The question is whether he is entitled to the B schedule land is the question he has to prove it.
Yes, to prove it.
Only that, that he, whether he is separately entitled to schedule B or not, or any other area. So this is a thing which can be very well decided as regards the question, as regards the loan which have been taken. In fact, what has happened is the issues which have been framed is very unhappily made. We have seen the issues. There is no issue as regards your counterclaim. Is there any issue?
This is some issues. Counterclaim regarding counterclaim, no issue.
No issue. So that counterclaim issue has to be brought in. Then the court has to decide on that application. Because this, he very well has to categorically come up and say that this much I want to prove it. And I reserve my right to prove the others. Now, where is this Mr. Storm? That is why I didn't sign that order. Because what I gave on that day was directing him to file his evidence. But there will be a difference if any additional issues are freed, which I think would be the requirement. Because there is no issue as regards your counterclaim.
Same issues, my lord, where my lord it is written by proved by defendant, proved by
Wrong how he has done. Because I looked into your counterclaim, the records were there.
lordship.
I looked into your counterclaim. There were many aspects which ought to have been framed as issues. They have raised a written statement also filed to that. But overall, both parties want partition, so there is no quarrel with that. So the question would be as to whether he is separately entitled to Schedule B is the question for which he may have to prove it. Because as both parties have, why do you have to go for an amicable partition, whether it is there or not, that is another thing. The issue should have been as to whether, in view of what is the stand of the plaintiff, whether he is separately entitled to only Schedule B. Don't you think so?
Lordship, that is there. That's what he has to prove whether he is entitled to that.
That he has to prove it.
That he has
Otherwise,
to-
both parties are asking for partition. He says that I have paid 14 lakhs out there. I have been discharging the loan in that regard out of 35 lakhs. That is another aspect. Taking into account he's not there, I can't do it anything. Huh? Okay, the petitioner is not represented. On the other hand, Mr. U.J. Saikia appears on behalf of the respondent. List this matter again on, we'll have it after vacation. On 16th of July, 2025. You tell him.
My lord, in this case, sample ground, page number 11, my lord.
Where is Mr. M. Sharma? None is appearing. What is wrong? Top of the list they have not looked into.
Expansive process order, my lord. I appeared and filed petition, two petitions.
Understood, Mr. Hussain. Where's the other side? We'll take it after some time. Let me complete the list. This top of the list matters. None of these councils are appearing. Yes, what is this?
My lord, the well witness to decree holder in respect of allotment of land, my lord. Stop, my lord.
Oh, the Sabua one.
Yes. my lord. The impugn order containing, my lord, the page 64.
You are appearing for Sabua.
Yes, Lordship.
Now, where is the question of going against them?
No, I am not going against them, Lordship. We
Who
have
is
allotted,
going against them?
My lord, the decree holder wants that by replacing me, they should be accommodated there.
How? Where is that order?
My lord, kindly see that the order contains page 63, start from page 63.
Page?
63, my lord.
Hmm.
Next paragraph, my lord, hard judgment, page 64, the operative part.
Which one?
My lord, second paragraph, hard judgment data from the report as well as from the verbal submission, the judgment data, it appears that judgment data is not tried.
Which page?
Well, page 64, my lord, 6.
64.
Yes, sir.
May I submit your lordship?
Hard.
Lordship, if not inconvenient, your lordship, after some time, your lordship.
Chalo. Abar serially lo.
Deeply okay.
Yes, Mr. Dev, what is this? What you are
Yes, sir.
challenging?
My lord, I am the plaintiff. The suit was for a partition and separate possession. So the suit was decreed. The lower appellate court have found the decree. Then my lord, matter came second appeal also dismissed. My lord, in title execution case, my lord, partly it is executed, record has been corrected. Only possession, delivery of possession nil. Now, my lord, this opposite party number 1 have come that he is the owner of the uh, land in the number 456 of the Schedule B. And my lord, he paid for impleading him as party in the suit,
Which
Well,
suit?
original suit.
That has been finished.
Now, that has been finished, second appeal finished, my lord.
Then,
Then, my lord, he has been made a party and the suit has been revived.
so final decree passed.
Final degree passed, my lord, title appeal disposed.
No.
affirmed the decree,
Initially, it was what? It was a preliminary decree or final decree?
preliminary decree.
So therefore, now he has come in the preliminary, because it has not been finally disposed of, that
Final.
means.
Finally disposed.
So the suit has not been disposed of. So he wants to be a party there.
He wants to be a party there. That the suit has been revived. But
No,
preliminary,
the suit is already there. Suit has not been disposed of.
but it has been revived.
Let's see the trial court's judgment.
Trial court order, my lord. At page 120.
So it's a preliminary decree.
Preliminary.
So the preliminary decree has been, then title appeal has happened. Where's the final decree?
Final decree, my lord. Final decree has not yet passed, my lord. Preliminary decree, it is on execution, my lord. Execution stage. Record has been corrected as per the decree.
So now what he wants?
He wants to make him implead him as a party defendant and to revive it, and to try the suit. All the suit is already, my lord, tried and disposed of. Well, he can very well appear in the execution case, my lord.
Precept has been issued.
Precept has been issued. And my lord,
Now he claims to be the owner.
he claims to be the owner.
Now partition,
Partition, my lord, the revenue partition has been done and the record has been corrected in entering the name of the plaintiffs.
then final, where is the final decree? It was a preliminary decree only
Because
passed.
it was a preliminary decree.
So where is the final decree?
Final decree, my lord, if the decree is not executed, then the final decree.
No, Mr. De, what is this?
It is, my lord, execution, my lord, half, it is partly executed, my lord.
On the
only
last day, on the last day of vacation, on the eve of the vacation, don't make that submission. People will laugh. When there is a preliminary decree partition done, the report, then on the basis of that, the court has to make up a
report has
final
been
decree.
Report has been submitted, my lord.
Where is the final decree? My therefore question is final decree.
Final decree not yet passed, my lord.
So now he wants to end. And why it speaks for amendment of the plaint?
My lord. Amendment means, my lord, his name will be entered as dependent. It's the amendment.
I think the normal course should have been for him to come under order 21 rule
My
97,
lord,
not at this May.
my lord.
But then also the suit is pending.
Well,
And how possession has been given to you?
the possession has not yet been given.
So therefore the possession is not, you said that partly this year.
Partly, it's, my lord, record corrected.
Cannot happen. The record has been corrected and then there has to be a final decree. Record has been corrected by them and then there has to be a final decree. Anyway. But this order is wrong. Anyway, issue notice, returnable. Why we are filing 115? Why?
150, if his petition is dismissed, then the suit will,
What?
if his petition is dismissed, then the suit will not be revived at this stage, my lord.
What is that? The proviso says if the revisionist application which have been filed before the trial court or whatever court would have led to the disposal of the proceedings, then only 115 will come. It is not your petition.
I allow it to correct.
No, oh, correct. After vacation. What happened on 19/6?
6 adjourned,
Till
22nd July.
it is seen, the learned counsel appearing on behalf of the petitioner at the outset submits that the instant petition ought to have been filed under Article 227 of the Constitution, exercising the supervisory, taking into account the above, the registry may correct the cause title and list this matter on 14th of July 2020. Yes, Mr. Solia, you are challenging.
Challenging order with 11-4, my lord. That your lordship will find at page 40.
Yes, what is this?
Here, the learned trial executing court, my lord, after rejecting the application for 152 for amendment of the decree, has instituted a commission under Order 26 Rule 9 for verification of the land
What?
by the, or identification of the land by the trial, by the revenue authority. But that has already been done, that decree is on a different land. For that, this 152 was there. In the execution case, petition, they have themselves mentioned this position, because when initially the matter was sent for at page 20.
Mr. Solia,
My lord.
on the eve of the vacation, will you like a dismissal or an adjournment? Either
No, my
order is
submission
right.
152 application has been dismissed.
Forever 152, under 47, the court has the power to do that. It is absolutely within the jurisdiction of the executing court to see that the fruits of the decree is there. And the power has been given and has been, the Supreme Court has made it clear in that judgment in the case of 2003 2 SCC, E2C or something. The Supreme Court makes it very clear that this power can be very well exercised by the executing court to see to it that by, if necessary, by issuance of a commission or so and so. And I have passed on that basis many orders, judgments, etc. So therefore, I am asking you, on the eve of the application, would you like a dismissal or a?
They want to amend the tag number and pata number of the land.
The court is not looking into that. The court is going to see as to how it is to be done. Kindly see here. What is the court's direction? Hence, it is directed. What is the application file? Look here. Now, the petition has been praying for amendment of the decree and passing of an essay. It is important to go to the history of the case and first here. The present petition has been filed for eviction and area rent based on so and relation to tenant. Over the time, the suit was renumbered as so and subsequently. The suit was decreed in favor of the plaintiff granting eviction of the area and area. This was affirmed by so and so. The decree holder filed the petition under section 151 for not for amendment or alteration of the decree, but to confirm the identification of the decretal land based on evidence led in the execution proceedings, addressing changes in the revenue settlement and clerical discrepancies in Dagnam. The decree holder filed the petition seeking correction or amendment of the decree based on it. However, after careful air, this court finds that such relief can be. It is well settled position that once a decree has been affirmed by an appellate court or revisional court, the original decree merges with the so-and-so. The Supreme Court has so-and-so. In the present, the decree passed by the so-and-so was challenged in appeal so-and-so. It is clarified that however, such correction can only be carried out by the court that passed the decree. On the prayer for amendments, then, however, in the interest of justice and to ensure that the decree which has been attained finally is not rendered in error due to administrative argument, must consider whether the decree as described is capable of being identified for the purpose of execution. Then, in fact, the first portion is wrong. You want, I can correct that first portion. The court has the power to look into it as to whether if there is any change out there. What is right?
They want to change the tag number. That means and pata number, because your lordship will see page 20. Revenue authority has already decided that. Page 20, the Mondal's report is an.
Where is the decree passed?
Decree was passed on 11/4/2001.
Hmm?
Decree of 11/4/2001.
Where is the decree?
Oh, I am not annexed that.
Oh. How will I know all these things?
It's not a change of tag numbers or pata numbers in the revenue record during verification. Tag numbers do not tell, and pata number. For that reason, they say that it is amendment to management. That was rejected.
Did you challenge the boundaries in your written statement of the suit land? Did you challenge the schedule of the suit land? In the judgment and decree which was passed, the correct tag number and pata number was mentioned in the judgment, but in the decree they have made that mistake. Yes, this is what has been written. And nothing can be found out with these type of, you have not filed all the documents. So therefore, I am again asking you, will you like to have a dismissal or an adjournment? Mr. D.P. Solier, the learned senior counsel, submits that taking into account that the judgment and decree passed, judgment and order passed by the learned trial court, as well as the decree which was drawn up, was not brought on record, he may be given some time to file an additional affidavit bringing on record the same documents. This is the matter on 16th of June.
After 20 minutes.
Okay. This is the matter on 21st of June. Very challenging.
Challenging, my lord, my amendment, my lord, prepared for amendment order 6/17 petition has been rejected. Page 67, my. I just want to, my lord, correct the tag number and pattern. Page 67.
What is the stage?
My lord, should are yet to be finished.
An oral agreement.
My lord, I'll take your lordship to the plaint.
Understood, but it's an oral agreement. I would have been understood if it was a written agreement, that couldn't have been done.
Please, lordship kindly come to page 22, paragraph 5 of the plaint. Whether this fact is believable.
Page 22.
Page 22, paragraph 5.
Yes.
That Partha Pratim Pal, the partner of the said partnership fund, started negotiating to complete the sale contract respecting the schedule C land. This is, my lord, that sale of the land, they want to say, and go down since the first day of November 2022. In this regard, 3-4 sittings to finalize the matter of sale was held at the residence of the landlords, and finally, in the last sittings on 12/11/2022, in presence of the landlords, the family members and the staff of the said farm, the offer of the landlords as against the sale of Schedule C land with godown had been accepted for the farm against the total consideration of rupees 2 crores and odd. Now, your lordship kindly see our objection. The two of the person, defendant number 2 and 3, my lord, they say that transaction took place on 12/11/2022. This is the oral agreement. And the defendant number 2 and 3 died 2011 and 2015. Now, how this dead person can sit on 2022 to enter into an oral agreement? Now,
Very
the
good.
entire episode of the thing is totally false, my lord.
Whether it is false, you'll file your written statement for that.
Written statement we have, in the meantime, we have filed. My lord, I'll take the lordship to paragraph.
No, it's okay. You have filed your written statement. The suit has not gone to any other stage. He's only asking for the amendment to be brought in by 1 to 6. Now, he's asking for that in place of the defend number 1, Srimati so-and-so be corrected as Srimati Devi Saraf, alias Sobita Devi Saraf. Devi Saraf, alias, you want to put the alias, Sabita Devi Saraf. And then all these things, and the landlord should be corrected as landlord.
That part is okay, my lord. Now in line page 54, you will also look at. In line 12 and 13 of para 4, the plain, the covered by Doug number so and so, be replaced covered by Doug number 520, pattern number 237.
Hmm.
Now they say, my lord, the document which we furnished, on the basis of that, they have filed the plain. Now, what are the documents, my lord, they did not annex? Well, the entire, if your lordship look at our written statement at paragraph 5 and 13, my lord, make the thing very clear. It's out and out a false statement everywhere. And we have stated in paragraph 13 very categorically.
But Mr. Datta, tell me, can I decide whether it is false or true?
Article 27, my lord, there is the error of fact also.
No.
I think your lordship will not look into all that.
I'm only concerned out here whether the amendment should have been allowed or not.
In the amendment, your lordship, the order passed, there is no illegality, I suppose.
Why?
Your
The
lordship, when you
order
see-
is in fact illegal on the
Lord,
basis that if I would have understood if he is asking for amendment of the agreement. He's not asking for the amendment of the
Your
agreement.
lordship, see the plaint, he is in fact asking for.
It's
the
an oral agreement.
Lordship may see, yes, they want to say it's an oral agreement. Now, your lordship may see at paragraph 29, page 29, paragraph 16.
Hmm.
So the agreement dated 12/11/2022 is an enforceable agreement. The plaintiff firm remained always ready and willing for the payment of balance consideration towards the value of the agreement and still ready for the payment. But
So
the
as regards the amendment, this is the second round of litigation.
first round, my lord, without hearing us, the amendment was allowed.
Tell
Was
him.
allowed.
Good, and I am hearing both and allowing it, confirming this, allowing the instant petition at last.
No, but ultimately, my lord, they want to say the entire basis on the basis of the oral agreement. Now here, they want an amendment on the oral agreement. Now, how the oral agreement can be amended?
They are not, therefore I am saying, it is their pleadings on the basis of which they say that there is an oral agreement. On the basis of that. So what they are asking for, that the dark number should have been this, but the dark number should be that. They will do it.
Now, your lordship may see the entire episode of the plain. Your lordship look at. Lordship will find that these are all the statements which cannot be believed because the deal was for sale of a particular land, that is the Shilk Sea. And it was amounting rupees 2 crores 24 lakhs and odd. And there was no agreement. And that we have agreed to, my lord, take rupees 2 lakhs. There is no receipt at all.
No, that is for bank.
Now, whether these story can be accepted at all. And they want now the amendment of the agreement, not amendment of the pleading. Amendment of the oral agreement.
Unfortunately, the Chief Justice has not given me the roster of RFA. If the RFA would have been given, then I would have taken it on appeal. But not that. So we will not go into that. Because first petition should be allowed this one. In 2 cases, I am not able to issue a notice even.
Lord, in that case, my lord, can I pray that let's file our affidavit against this?
Mr. Dotto, kindly don't make that submission. Somebody that they asked for, that I want to file affidavit against in a revision application like.
I'm aware of that, my lord. what
I
you lord.
was very, I do not like to say and repeat
No,
it for you,
My lord, I could
considering
understand.
your stature. Allow it, fight it out. 25,000 is the cost.
Only thing is not a case of amendment, for they want an amendment of an agreement ultimately.
No, I would have understood. No, just tell me one thing. where will they go then to change it? If it was a written agreement, obviously, then section 26 of the Specific Relief Act will come in. So that could have been permitted. But if it is a oral agreement, it is based upon the pleadings. So the pleadings, they say that it was this dag or now they want to change these dags. You can very well question that.
Your lordship has seen that the two persons already expired. Now they have deleted from the ballot by filing an application. So the fact remains you have filed and sued against the dead person. Now, and they're saying that they entered into an agreement on 2022, whereas this two person died, one in the year 2011, another in the year 2015.
But this is not the amendment they are seeking here.
So ultimately, my lord, agreement was between these people, the person who.
I don't know what that in.
No, the amendment is what he
Only
is
for the
seeking is at page 44.
And this oral agreement entered into along with those persons who has already expired. That's the crux of the matter, my lord.
You know, I've given a lot of hearing to both. Then going to Supreme Court, you cannot say that I have not given hearing to both. Heard Mr. T.J. Mohanto, the learned senior counsel assisted by so-and-so. And the S. Dr. Senior counsel assisted by so-and-so, who appears on behalf of the respondent number 1. Anybody has seen any government counsel anywhere? Have you seen Mr. T.R. Gogoi or Mr. K. Bhattacharjee? Either of it. In the corridors. Anybody has seen anybody? Mr. T.R. Gogoi or K. Bhattacharjee, they are the government counsels who appears. Find it out, whoever it is. Get hold of this government counsel and put their name. So and so appears on behalf of the performer defendant number. No, it is Dokan. Appears on behalf of the respondent number 1, comma. Taking into account the subject, taking into account the issue involved, comma. The presence of the performer respondent number 2 and 3 is not required. This court takes up the instant proceedings for disposal at the motion stage itself. It is seen from the materials on record that the petitioner herein as plaintiff had instituted a suit being title suit number 31/2024, seeking specific performance of the agreement dated 12/11/2022, oral agreement dated 12/11/2022, entered into between the petitioner and the respondents and the respondents and the petitioner and between the petitioner as plaintiff and the defendants. Along with consequential reliefs. Full stop. The defendant number 1, who is the respondent herein, had already filed a written statement. Full stop. While filing the written statement, it came to the knowledge of the petitioner that the defendant numbers 2, 3, and 4 were nowhere related to the suit land, and accordingly filed an application under Order 1, Rule 10(2), read with Section 151, for striking out the name of the defendant numbers 2, 3, and 4. The said application was allowed, and thereupon and therefore the present suit seeking specific performance is against the defendant number one, who is the respondent herein. The plaintiff, the petitioner further had filed an application under Order 7 Rule 11, read with section 151, read with Order 1 Rule 10(2) and section 151, seeking amendment of the plaint full stop. The amendments which have been sought for have been duly mentioned at paragraph number 7 of the said application. Full stop. The said application was registered and numbered as petition number 739/24. Full stop. A perusal of the amendments which have been sought for reveals that the petitioner is wanted to insert, wanted to replace wanted the change in the respective dark numbers in respect to the land which was alleged to have been agreed to be sold to the plaintiff oblique petitioner. First, written objection thereagainst was filed by the respondent herein, stating inter alia that the amendments which have been sought for where is your written objection?
Page 60, 60.
60. That the amendments which have been sought for would change the nature and character of the suit full stop. Apart from that, it was also alleged that the plaintiff oblique the petitioner have resorted to all falsehood while seeking for amendment, and the said aspect would be apparent from the fact that initially the suit was filed against the defendant numbers 1, 2, 3, and 4, alleging that there was an oral agreement with them, and subsequently the defendant number 2, 3, and 4 were sought to be struck off on the ground that they were nowhere connected to the suit land. It is further seen that the learned trial court, by the order dated 13/3/2025, rejected the amendment application on the ground that what amendment was being sought for was in respect to amendment was in actual an amendment to the agreement and not to the pleadings. Full stop. It is under such circumstances the present application has been filed. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to their respective submissions. Full stop. It is relevant to take note of that the plaintiff oblique the petitioner seeks amendment had filed the suit seeking specific performance of an oral agreement. Full stop. While stating an oral agreement in respect to the land described in Schedule C, na? Huh? Schedule C. To the plaint. Full stop. The basis on which the plaintiff alleges that there is an oral agreement is by way of pleadings. Full stop. This is not a case where the plaintiffs have sought for amendment of the pleadings, which was contrary to the written agreement. Full stop. Under such circumstances, the ground on which the learned trial court had rejected the amendment application does not appear to be appears to be an erroneous exercise of jurisdiction, inasmuch as on the basis of the pleadings the plaintiff have alleged that there was an oral agreement. Full stop. This court have further taken note of that the trial is yet to begin. However, the defendant, the respondent have already filed their written statement. First, considering the above, it is also relevant at this stage. This court also finds it relevant to observe that the submissions made by Mr. S. Dutta, the learned senior counsel, wherein is submitted that the defendant, the plaintiff, oblique the petitioner have resorted to all falsehood, as would be very much apparent from the materials on record itself. Full stop. The question as regards certain facts are not correct or are correct or not cannot be decided in the proceedings dealing with the amendment of the pleadings. It is the opinion of this court that the defendant oblique the respondent herein would be at liberty to reply to all such statements, to file its additional written statement. That such grounds can very well be taken as their defense and which shall be adjudicated by the learned trial court. Considering the above, this court therefore disposes of this petition with the following observations and directions. The amendment sought for by petition number 739/2024 dated 6/7/2024 stands allowed. Full stop. Number 2. Next date
15 July.
15. It has been submitted that the next date is fixed before the learned trial court on 15/7/2025. On the said date, the plaintiff oblique the petitioner shall file the amended plaint. Failure to do so, it would consequences under Order 6, Rule 18 shall ensue. Number 3. This court duly takes note of that the amendment which have been sought for duly takes note of that on account of the amendment sought for at a later stage. And in the meantime, the written statement, the plaintiff, the defendant having already filed, comma, the defendant have been put to undue harassment. This, in the opinion of this court, can be duly compensated by certain cost. Accordingly, this court imposes a cost of rupees 30,000 upon the petitioner, which has to be deposited before the learned trial court at the time of submission of the amended plaint. It is observed that the deposit of 30,000 shall be a condition precedent for acceptance of the written state amended plaint. Full stop. Number 2. This court further observes that the respondent oblique the defendant would be entitled to 25,000 of the 30,000. And for that, and upon an appropriate application being filed before the learned trial court, the said amount be the learned trial court shall pass upon an application being filed, the learned trial court pass appropriate orders. The remaining 5,000 be deposited. The learned trial court shall disperse the remaining 5,000 to the District Legal Service Authority of Dhubri.
Wait.
Nowadays, I'm doing some social service. 25. No, last two. That day, in one case, what I did, the trial court gave 2,000 rupees. I imposed 25,000 rupees. And of that 2,000, I gave it only to him. And 23,000 to the district lawyer. Oh, yes, paid.
I have paid.
Good. Laugh something good. Next.
On that day, itself, Lordship, although the learned trial court put up the case for tomorrow.
Very good. As the state gets some money. Now come to the point. What is your case? Are you not asking for the final relief? That's the final relief.
Situation compel me.
Huh?
So Lordship, kindly produce my document.
No, are you not asking for a final relief? That is my only question. Not other thing. What you are asking is the final relief?
To some extent.
What is that to some extent they should not be allowed? That's your prayer in the plaint.
Yes, sir.
How can the court grant a temporary injunction restraining them from using? What is the yes, there is no quarrel. There is one judgment of the Supreme Court, 2004, wherein the Supreme Court category says in certain cases there can be a final relief also can be granted. There is no quarrel with that. But you have to show certain things which is more than a prima facie
Yes.
case.
That I'm going. The petition is zonal unit.
Huh?
Zonal unit. Registered under trade union. If your Lordship kindly peruse my
Who are the defendants?
Jitu Hazarika and
And that I know. There are two names. I can also say Jitu Hazarika and Harish Bhuyan.
Yes.
Who are they?
they are ex-employed.
So they are using your name.
Yes, sir.
As what?
As secretary and president.
How?
That is my main.
Have you filed FIR?
Yes, Lordship. I have filed.
Nothing has happened.
No, Lord. I also inform all authorities
You have informed.
and lastly, Lordship, if your Lordship kindly peruse my letter.
Yes, Mr. Sharma, what is this?
Here association was formed in the year, this plaintiff number 1. This was earlier under the Bharatiya Railway Mazdoor Sangh. In the year 2015, a new committee formed. That committee did not work properly. In the year 2019, a new press committee was formed, wherein these two persons were entered. They were in service of the railway. After this new committee was formed with the defendant number 1 and 2, the plaintiff number 2, that person was the working president at the time. She was unhappy, and therefore she wrote a letter to the Bharatiya Railway Mazdoor Sangh that I am not happy with your activities, therefore I shall not continue. It's in the year 2020. Since then, these two persons and a new committee is working. They are regularly paying their tax also, not tax, it's the audit report and submitting the payment. So they are continuing as a new committee under the Bharatiya Railway Mazdoor Sangh. These persons in the year 2021, they took affiliation of the Bharatiya BJMS, Bharatiya Jatiya Mazdoor Sangh. And now they are claiming that they are the real organization. Here in this case, the first duty of them was to first pray for a declaration that their association is the actual association. Without the declaration, they cannot claim any relief. This is number 1. Number 2, the committee of these defendants was formed in the year 2019. Now it is 6 years.
What is your committee name?
Lordship, I am the Bharatiya Purvottar Sীমান্ত Railway Karmachari Sangha, and it is affiliated to the Bharatiya Railway Mazdoor Sangh since the year 1971. Affiliation was since then. Now this a class of people from this organization, they are from a separate committee. They took under the same name took affiliation from the Bharatiya Jatiya Mazdoor Sangh, and now they are claiming that their organization is the actual, and claiming that these two persons are working illegally, and therefore they are praying for injunction.
Chalo, we issue notice, we'll hear it after vacation. No, India. No, no, heaven. Mr. Counsel, no heavens will fall.
Lordship,
No heavens will fall.
Duplicate copy of
time bar.
duplicate copy of PAN card, everything is duplicate, Lordship. They are using duplicate copy.
Mr. Counsel, first of all, you have to understand what mistake the trial court and the first appellate court had, whoever had done for granting you an injunction till the disposal of the suit. I'm not going to do this by giving you an injunction as of now. No. This matter has to be disposed of. This matter has to be disposed of. There's no question of an interim basis out here. Other side is duly represented. We'll hear it after vacation. Issue notice making it returnable on 21st of July 2025. Mr. So-and-so appears on behalf of the respondent numbers 1 and 2 and accepts notice. He further submits that being a caveator, he has already been served extra copies. First, taking into account, there is no requirement of issuance of, there is no requirement of any further extra copies to be handed over to Mr. So-and-so. First, the petitioners herein has challenged the order dated 28/5/2025 passed by the Additional District Judge number 3 Kamrup Metro at Guwahati in Miss Appeal number 1/2025, whereby the order dated 17/12/2024 passed by the learned Civil Judge Senior Division number 1 Kamrup Metro in Miss case number 1114 1/2024 connected with title suit number 633/2024 was set aside. Full stop. This court, having heard both the parties, is of the opinion that the question of passing an interim order with that is of the opinion that the question of passing an interim order at this stage without properly hearing both the parties would not be, no, is of the opinion that the matter requires an urgent hearing. First, accordingly, on 21st of, accordingly, on the next date fixed, comma, this court shall make an endeavor to dispose of the instant proceedings.
Sir, my name may be reflected, so D Sharma. Name of Arthur may be reflected, right? It means
Don't worry.
Passed in title appeal, my lord. By the Honorable Civil Judge, my lord, Qatar, my lord. Page,
Huh?
Honorable Civil Judge, my lord, Qatar, my lord, page 30 is the English judgment.
Where?
Page number 30, my lord,
30?
30, my lord. My lord, suit is dismissed. I am the landlord tenant dispute, my lord. I am tenant here, my lord. And I am in the original suit, I am the defendant. Then suit was dismissed, then they have filed the appeal, the landlord has filed the appeal, then appeal was partly allowed to remand back the matter to decide the correct points of determination. Then there are some, this revision I have filed. The suit was under some urban area rent control act, 1970. Page 36, my lord, paragraph 11, where my lord appellate court
No, there was a remand back.
remand back.
Then what happened?
Uh,
Appeal is allowed partly on contest. The impugned judgment is hereby set aside and the suit is remanded back to the learned court of the Munsif with directions as reflected above. Then,
and against that order, I have filed this revision.
what is this business of filing CRP against that order? This is framing of additional issues. Shall pass a judgment afresh after giving both the parties an AR to argue whether the defendant is a defaulter in payment of rent, whether the defendant is liable to be evicted from the suit land, and so and so and so and so, and any other relief. So then, what is wrong?
Suit, my lord.
Now, first and foremost, tell me,
Suit was declared ex parte against me, my lord. I was not allowed to file the written statement, my lord. Then, partly I have allowed to cross-examine the plaintiff, my lord.
now, are you challenging this order challenging the order of 28th of April 2021, page
Yes,
30,
yes, my lord.
isn't it?
Yes, ma'am. Passed by the, in the appellate court.
Then, tell me, how is it possible? Who are you?
I am the, my lord, defendant in the original suit.
Who are you?
Tenant, my lord.
Huh?
I am the tenant, my lord. Shri Ramkelan Rabidas. Ramkelan Rabidas is the petitioner here, who is the defendant in the original suit and the tenant.
Did you file your written statement?
Considered ex parte in the. It is. So we have allowed to cross-examine the plaintiff and we have placed our argument. In the
Then?
Then the suit has been dismissed for the eviction. Then they have preferred the appeal, the landlord. Appeal, in the appeal, just partly allowed by the appellate court, that is remanded back to frame the points of determination correctly.
Points of determination or issues?
Page 36, paragraph 11, why it was remanded back, my lord.
Mr. Counsel, are you the tenant? Why you are fighting this? Why have you filed? He should be filing it. That is why I am asking you. First, why you are filing it? Unless You don't know what is the consequences which will befall upon you. Number two, how are you filing it?
First, my lord,
It's a landlord-tenant dispute.
landlord-tenant.
You file an appeal.
Lordship, appeal allowed, remanded back the matter, and there is no infirmity, Lordship.
Now, why did you file an appeal?
It is filed by the defendant, Lordship. Lordship, kindly have a look at page 37. There is no finding at all by the learned trial court whether there is any landlord-tenant relationship. That's why learned
The
trial court.
truth of the plaintiff is dismissed ex parte. And against that, you file an appeal. Now it has been remanded back.
By the appellate court, against which they have defended them.
Why?
Firstly, just to find
Who has asked you not to file? Where is the limitation period? Why you are coming into those issues? See that judgment. 2007 SCC 357. Justice M. Jagannath Rao. A Visit Tea Company or something. United Bank of India versus a Visit Tea Company. Paragraph 16. You do one thing. We are exercising 227. Okay. We do one thing. We decree his suit. We do one thing. The suit could not have been dismissed. So we decree your suit.
only the state cannot recognize.
There is no denial that you are.
Yes, my lord.
Do you admit that you are a tenant or not? So forget about the boundaries. We are not concerned. He has a bona fide requirement. Matter over. Defaulter not necessary. As per the judgment, I am allowing this his suit interfering with that remand. You want the interference to that remand order, I will interfere with it. And then decree the suit which has been passed and thereby oust you. How much time do you require to vacate? How much? Better withdraw. Unnecessary, don't file these type of petitions. Go and fight there. File your written statement there. Heard, Mr.
Yes, Hazarika.
The learned counsel appearing on behalf of the petitioner and Mr.
L.R. Majumdar.
So and so appearing on behalf of the respondent. Pusto. The revisional jurisdiction of this court have been invoked challenging the order dated 24/2021, passed in title appeal number 21/2018, whereby the appeal filed by the respondents herein was partly allowed by remanding the appeal back to the learned trial court, that is the court of the Munsif Lokhipur Kachar, to decide the appeal afresh on the basis of the said points of determination. The learned counsel appearing on behalf of the appellant petitioner submitted that in view of the judgment of the Supreme Court dated so and so in United Bank of India versus Abhijit so and so, reported in 2007 SCC 357, once there is a remand by setting aside the judgment, the suit is deemed to be setting aside the judgment and decree passed by the learned trial court, comma, the suit is deemed to be pending. Full stop. Therefore, without providing an opportunity to the defendants, to the petitioners to file their written statement and framing points for determination, the learned trial court, first appellate court, that is the court of the civil judge number 1, Kachar Silchar, had committed an error in exercise of jurisdiction. This court have duly taken note of the said submissions so made, as well as the submission made by the learned counsel appearing on behalf of the respondents herein, who are the plaintiff. It is the opinion of this court that once the suit is remanded back to the learned trial court, the suit would be deemed to be pending. Under such circumstances, the learned first appellate court, by formulating the points for determination, have taken away the right of the petitioners herein to file the written statement. This court also takes note of that if the trial court is permitted to proceed with the appeal of a suit in the manner as directed by the learned trial court, first appellate court, it would result in causing prejudice to the defendants, the petitioners who are the defendants in the suit. Considering the above, this court therefore disposes of the instant proceedings with the following observations and directions. First, this court is not interfering with the order dated 24/2021, passed in title appeal number 21/2018, insofar as remanding the setting aside the judgment of the learned trial court dated 29/9/2018, passed in title suit number 68/2012, and remanding the suit back to the learned trial court for decision. This court, however, interferes with the order, the said order dated 24/2025, only to the extent whereby the learned first appellate court at paragraph number 16 had formulated certain points for determination and directed the learned trial court to decide the suit on the basis of the said points for determination. Number 3, this court, it is seen from the records that there is a stay to the further proceeding, stays there, na?
Yes, madam.
To the further proceedings of title suit number. This there, na? There's a stay to the impugned order dated 24/2021, passed in title appeal number 21/2018. The stay to the order dated 24/2021 entitled appeal number so and so amounts to stay of the title suit number 68/2012. Accordingly, this court therefore vacates the order dated vacates the order dated 8/12/2021, whereby titles the order dated 24/2021 passed in title appeal number so and so was stayed. Full stop. This court fixes the further proceedings of title suit number 68/2012 before the court of the learned junior division number 1. Junior division, na?
Civil judge junior.
Huh?
Civil junior judge one.
Civil Judge Junior Division 1, Lakhipur. Subdivision, na? Subdivision is there.
It's cast.
Junior Division. Junior Division 1, Lakhipur. Subdivision in the district of Kachar. Kachar, Buliga. On 1/9/2025. Full stop. On the said date, comma, the petitioners herein who are the defendants in the suit is given the liberty to file their written statement without fail. Full stop. Then next. This court further observes that if the written statement is not filed on the said date, the learned trial court shall proceed with the suit in accordance with law.
I'm deeply open.
Mr. Parvez.
My lord, impugned order is at page 209.
Yes, what happened?
The pro forma defendant a well known from the State Bank of India by creating mortgage over his property. And when the loan becomes NPA, bank initiated action under the provision of SARFAESI Act, and bank has also filed original application before the TR. Thereafter, recovery proceeding started before the TRT, recovery officer. Then, when the property was attached in the year 2019, the recovery officer came to know that one proceeding is going on before the district judge. Then recovery officer directed us to file petition there because for same property, the district judge has also attached the property, which was mortgaged with the bank. Then initially, one advocate of the bank filed one petition for adjournment in money execution. And then
You filed the petition under Order 21, Rule 58.
58,
That was dismissed.
that was dismissed on the ground of res judicata.
Whatever may be, it
Yes,
has
ma'am.
been dismissed. If it is dismissed, then Order 21, Rule 58(4) says it's a decree. Why should we go into all these things? File appeal.
Your lordship,
I'm very clear on this. Wait. And you see Order 21, Rule 58(4).
twenty-one.
Rule 58(4). అలాగే. There is, it is there means that is the only thing. Otherwise, there is no other,
But it's not decided on merit, my lord.
not necessary. Rejudicata is also merit.
So whether there was a res judicata, the lordship has to say, because the district has no jurisdiction.
What do you want? Should I dismiss it simply on that, or you want to withdraw and file an appeal? Appeal lies where?
Should lie here.
Lie here.
But now this one difficulty, the order was passed by the district judge, my lord. Now with the commercial courts coming in, my lord, perhaps we'll go to the commercial court and a commercial appellate division subject. Because it's an execution arising out of an arbitral proceeding.
So the appeal will be filed where? The commercial appellate court.
But given that the district judge had passed the order prior to the coming, it should come here only. Yeah.
You have to file an appeal. Heard Mr. A. Parvez, the learned counsel appearing on behalf of the petition. And Mr. B.D. Deka, who appears on behalf of the respondent. The present proceedings arises out of rejection of an objection filed under Order 21, Rule 58 of the Code of Civil Procedure, 1908. It is relevant to take note of the provision of Sub-Rule 4 of Order 21, Rule 58, which stipulates that any decision made under any decision on the any adjudication made to any claim or objection under Order 21, Rule 58, the order made thereon shall have the same force and be subject to the same conditions as to appeal or otherwise, as if it was a decree. Full stop. Considering the above, comma, an appeal lies against the said order. Under Section 96 of the Code of Civil Procedure, 1908. First, in this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of wherein the Supreme Court categorically observed that when the Code of Civil Procedure 1908 provides a remedy, comma, the question of exercising the jurisdiction under Article 227 of the Constitution does not arise. Paragraph so and so, duta আছে না? Of the said judgment are reproduced herein under. First, taking into account the above, comma, as there is an appellate remedy available as provided under the Code of Civil Procedure 1908, comma, this court is therefore not inclined to exercise its jurisdiction under Article 227 of the Constitution. First. Next. This court further duly takes note of the submission of Mr. A. Parvez, the learned counsel appearing on behalf of the petitioner, to the effect that the petitioner, under the bona fide belief and on legal advice, has filed the instant proceedings and have been pursuing the instant proceedings diligently He therefore submits that the period during which the instant proceedings have been pending be excluded while computing the period of limitation. First, taking into account the above, comma, this court closes the instant petition on the ground that the instant proceedings cannot be entertained under Article 227 of the Constitution. First, the petitioner herein shall be at liberty to file appropriate proceedings by way of appeal before the competent court. First, the period of limitation, the period from 27/5/2024 till date be excluded while computing the period of limitation.
Send back. The
Huh?
execution has been halted. The records we send back.
The records be returned to the court below.
Like,
What is this?
The limited issue involved is this, madam, that whether,
You always come up with a limited issue.
Yes,
What is
madam.
that?
whether the defendants can set up their counterclaim, madam, after issues are framed. Under order 8 rule 9. Once the issues are framed, whether they can set up their counterclaim. Now, the thing is that, madam, the plaintiff is a tenant under the defendant, madam. So he entered into some agreements, tenancy agreement, oral tenancy agreement in the year 2002. Thereafter, my lord, in the year 2019, the rent was increased to 2,000. And then, my lord, when it was increased further to 5,000, my lord, there was a dispute and we filed a suit. The suit was for, my lord, declaration that he is a tenant under the defendant, my lord, and permanent injunction. The defendant filed written statement taking a plea that, my lord, the suit is barred under section 40 of the Assam Tenancy Act. And also, my lord, the plaintiff is a defaulter and that the tenancy agreement has elapsed. Thereafter, my lord, the lower court frames 2 preliminary issues, my lord.
Issues not framed,
The court framed 2 issues, my lord. Well,
preliminary issues.
standing in this, my lord.
Your understanding is absolutely wrong, taking into account that all issues are to be framed.
Yes.
So therefore, framing of 2 issues is no issues.
The issues of that matter, the issues of law, the court may take up and the settlement of the other issues, the court may postpone it. Here, my lord, the court only framed 2 issues, my lord.
That is not done.
It can be presumed that the court has formulated the issues.
Then What is wrong?
And thereafter, my lord.
Why
how-
you are challenging?
but thereafter, my
You
lord,
understand so much, then why you are challenging?
thereafter, my lord, how can the defendant again, after framing of issues, because
Framing of what issues? Preliminary issues.
then
The law says that all issues are to be framed,
Yes.
including preliminary issues, and then he may very well decide those preliminary issues. That's a different thing. But the other issues have not yet been framed.
but the court has framed these issues now.
That issues would not have no relevance. The whole- Mr. I'll pass a very short order. Mr. Chaudhary, you want to say something? Heard Mr. S. Das, the learned counsel appearing on behalf of the petitioner, and Mr. D. Chaudhary, the learned counsel appearing on behalf of the respondents. Pusta. The petitioner herein have assailed the order dated 31/7/2024, passed in title suit number 155/2024, whereby the petition number 78/2024, filed by the plaintiff, filed by the defendant under order 678,
Order it rule.
rule 9, read with section 151 of the code, was allowed, thereby accepting the additional written statement cum counterclaim. The petitioner herein have approached this court. The petitioner herein, who is the plaintiff, have approached this court on the ground that after framing of two preliminary issues, the learned trial court could not have accepted the written statement, the counterclaim. This court have duly perused the impugned order, and from the materials on record, including what have been discussed by the learned court of the civil judge, number 1, it transpires that the trial court is yet to frame the issues, frame all the issues in the suit. The framing of two preliminary issues is the concept of framing only preliminary issues and not the other issues is completely foreign to the Code of Civil Procedure. Taking into account the judgment of the Supreme Court in the case of Ashok Kumar Karla versus Wing Commander Surendra Agnihotri and others reported in 2022 SCC 394, it is saying that till the framing of the issues, a counterclaim can be filed. As in the instant case, the issues are yet to be framed, the learned trial court was therefore justified in accepting the additional written statement cum counterclaim. In the opinion of this court, the learned trial court have not committed any error in exercise of jurisdiction for interference by this court under Article 227 of the Constitution, for which the instant application stands dismissed. The interim order passed by this court on 13/9/2024 stands vacated, and the parties are directed to appear before the learned trial court on 30/7/2025, on which date you have filed your additional written, on which date you file your counterclaim, on which date the petitioner, who is the defendant, a plaintiff in the suit, petitioner, who is the petitioner, who is the plaintiff in the suit, shall file their written statement without fail to the counterclaim. Shall file their written statement on or before that date, on or before. Then
Then Lordship, the court discussed that issue in paragraph 9 and 10, but thereafter the law that pay and recovery but I'll come to pay and recovery later on, Lordship. But ultimately directed the insurance company to pay. There is no pay and recovery order. As such.
Okay.
And Lordship, after the amendment, then regarding pay and recovery now, Lordship, this case is of 24. After the amendment of the MB Act, Lordship, that
I am
provides.
not agreeable to that submission.
Okay.
There are 6 high courts who have turned down that submission. I am one of them who will pass one day an order. In the meantime, you make the payment. We'll go with the question of recovery, how to be made. How much is the amount to be paid? 1,78,000 plus 6% interest. You deposit it. Let it look. This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 1/12/3/2025 passed by the learned member Motor Accidents Claims Tribunal, Srirang Kajolgaon in MAC case number 14/2024. Pusto. The only ground of objection which has been taken. Other grounds are rejected. What are other grounds? Let me reject it.
It will be 15,000. Court has given loss of estate. The amount is for loss of estate only, 1 lakh something. Lordship. Pronouncity it is 15,000 and then a 10% increase in every 3 years. Because he was not dependent, dependency is not given. Only loss of estate of 25% of loss of dependency. But as per pronouncity, Lordship, it is only 15.
Why only one? Somebody died.
That case. Died.
How much it has been awarded?
Lordship, loss of estate, he was not dependent on the deceased.
No, why it is only 1,78,000?
Because 25% of the court has said loss of estate as per 25% of that amount, dependency amount.
No. I don't understand why only 1,78,000 has been given.
Lordship, the loss of dependency, the court calculated as 5,80,000,
Ah.
and out of that, 25% of as loss of estate is granted by the court.
I'm not
Means he was
understood. So, so the question of there is no other person who will get it. Who is the claimant? Son. So he had a son. Then why 1,78,000 is being granted?
Lordship, so that loss of estate.
Ah.
45,000 and that dependency came to 5,80,000. Lordship will find that it.
No. That kindly come to page 17. Thus, the compensation comes to the following: loss of dependency 5,80,000, loss of estate 25% of the loss of AR 1,45,000, funeral expenses and others 33,000. The claimant is thus entitled to 1,78,000. Why he has come to 1,78,000? That is why I am not understanding. Why isn't his doesn't he have a son?
Son,
Where is that observation?
Lordship. Lordship 12. Admittedly, the claimant is the son of the deceased. There is no sufficient evidence that he was dependent on the deceased. Rather, PW1, the claimant admitted that he is a grocery shop owner. A legal representative who is not a dependent of the deceased cannot claim compensation against the head, a loss of dependence. He would only be entitled to compensation against the head of loss of estate in such a case. The citation is given. In order to ascertain as to what would be the just I have taken the consideration the ratio laid down in the case of Sarla Verma so and so. Having ascertained the relevant factors, the just compensation for deceased come to as follows. Multiplied, then came to the dependency, and out of that 25% is given as the loss of estate.
What order is this? I don't understand.
thousand as per no fault liability. So that was earlier. Later on, these cases came. Our High Court also gave that lordship, that when they are not dependent lordship, there is a compensation for dependency in all the cases. If they are not dependent lordship, then loss of estate and funeral expenses, the expenses or medical expenses that they get.
Who have evolved this dependency aspect? The Supreme Court.
If they are, the dependent part is there.
What are
Everyone
you
can, the case, a representative can, or a legal lawyer can file a case, no issue with that. But the dependency has to be proved that they were dependent on the deceased. That's it.
So, person who is not dependent, there is no compensation. For what? What compensation?
State that they get.
Tell
And
me,
earlier-
what is the basis on which it has been done? Claims tribunal. For claim, an application for compensation shall be made under 163 by the person who sustained by the owner where death has resulted from the accident by all the legal representative here, provide all the legal they have not joined in the application for compensation or demand shall be made at 12 shall be included as provided. So this is judicially evolved. I think we need to change it. You deposit that all the amount. 5,80,000 and plus here, 1,45,000 and 33,000. Don't worry. There is one judgment delivered by me in future generally. If they are entitled to 168, they should get it. Well, let us see the judgment. This cannot understand because the court, the law does not say that. It is said about just and fair compensation. About the debt, any person, he did not, a person may suffer many aspects. Are you saying that a person, if the son is working out there, he will just get 45,000? I'm asking you. Only if you funeral and when there is a gross negligence. Because he cannot go to the civil court. Can he go to the civil court?
Because there is mistake.
Then, can that be? That cannot be the law. We admit this on this aspect. There is an appeal file under so and so. It is seen that the learned trial court, learned tribunal, had arrived at the amount of rupees 5,80,800 as the loss of dependency. And further, amounts of rupees 1,78,000 was awarded on conventional.
Loss of estate, 25%.
That is conventional. That is on conventional heads. The learned counsel appearing on behalf of the appellant submitted that taking into account that there was only one legal representative the amount of rupees 1,78,000 so awarded on conventional aid was beyond what have been decided, beyond what has been judicially evolved in the case of National Insurance Company Limited versus Pranay Sethi, reported in 2017, 16 SCC 680. Full stop. This court inquired with the learned counsel appearing on behalf of the appellant as to why the loss of dependency has not been awarded. The dependency arrived at rupees 5,80,800 have not been awarded. The learned counsel submitted that the said amount has not been awarded, taking into account that the claimant being not a dependent would not be entitled to compensation on the head of loss of dependency. The question arises that from a conjoint reading of section 166 and 168 of the Motor Vehicles Act 1988, as to whether the reading of conjoint reading of section 166 and 168 as to when legal representatives of the deceased on the death of an accident is permitted to file an application seeking compensation. And section 168 of the Motor Vehicles Act 1988 mentions about just compensation and not denying compensation to the legal representative, whether he is dependent or not. Can the trial court, can the tribunal can the tribunal deny such compensation if the if the claimant was not a dependent? First, taking into account the said grounds of objection, the instant appeal is admitted, call for the records and steps be taken upon the respondents by registered and usual. I number so and so. This is state subject to deposit of rupees. How much it should be as per you? How much it should be as per you?
Uh,
It's 47,000 something now.
yes. Seven.
Now it is how much? 5,100.
But
Come up
then
with that amount.
it-
This judge, he writes so. This order is very difficult. Funeral expenses and others will be 33,000. Consortium will be how much? 45? No, it will be more than that. How much he did there? 40 into, there'll be two revisions. Subject to deposit of 84,000 is state till the next date. Next date issue notice to Koribo, returnable on 15th October. Huh? State subject to deposit of 80,000 so and so, he do amount to collect plus along with interest at the rate of 6% per annum from the date of filing of the claim proceedings within 6 weeks. Pending day I state only till the next, subject to deposit of this.
Vehicles involved,
Hmm?
3 vehicles involved. And the entire liability has been settled on us. But the PW3, my lord, very specifically in his cross-examination stated, my lord, the accident happened, my lord, between the, my lord, bike where this person was riding, the claimant was riding as a pillion, and another bike where that bike rider died. And this person also fell down and got injured. Now, the bike which I represent, or my company represents as an insurer, is the bike which got entangled into the accident later on. Lordship will find the PW.
How much it has been awarded?
9,50,000, my lord.
Chalo?
Page 44, my lord. PW fees, my lord, cross-examination is recorded.
So you say how much you should pay?
My lord, our case is that we couldn't have been settled with the responsible because it was the, my lord, other vehicle which was responsible, my lord, because the accident took place earlier. We just got entangled in the process. Now,
Is it your case of contributory negligence? No.
our case is that,
No negligence.
because
You are?
Lordship, I am representing for respondent number 1, Lordship. Lordship, we have already filed caveat, Lordship. Lordship, we will engage a senior advocate, Lordship. Kindly allow us some time.
Hello. We'll have it after vacation. It's the matter after vacation. You are appearing for caveator. Ms. So-and-so appears on behalf of the caveator and the caveat stands discharged. Full stop. She submits that full stop. Ikonot Dibo list the matter again on 16th of July 2000. Madam, I'm not going to take up this. Not necessary now. I'm not. Is it a case for dismissal? Strong case? Then where is the substantial question on law?
Tell that I have no readiness and willingness.
What?
Readiness, willingness was discussed, lordship, and whole.
You are the plaintiff. Suit has been dismissed on readiness and willingness. Why?
That
Now, why readiness and willingness the court went into?
lordship on 30. Yes, lordship. And that there is delay, lordship. So there is no readiness and willingness.
Hello? There is one judgment on which we hold it and dismiss your suit, appeal. There is judgment to put. The Supreme Court categorically says that whenever a suit has been filed, irrespective of the limitation being there of 3 years, but then also if a delay in filing the suit also shows that you don't have any readiness and willingness. Readiness is
Serve notice to defendant,
when did you serve the notice?
the date of agreement 18/10/10, and I served the notice 23/9/13.
So why did you wait till then?
Approached him for putting signature to the application forms and denied.
So you must have approached him as per the agreement within a particular time.
Posted at lordship half.
Aflong is where? United States. No, then?
And
Yeah.
lordship
No, bad case, bad case. Let us dismiss your case. 1 second appeal finished is good for the day. No case.
And then
Existing
with
ERL
leading
is
lordship.
entitled to get the ER signed for is entitled to decide the amount. Sale of the money, finding and
Date your lordship, the pleading by the plaintiff.
permission to the public for payment. So you knew it. There's no mention of the good. Sure.
Page
No, madam, I think this is a case for dismissal. Therefore, that is what I told you. Don't do a bad case before me. You'll get better, good judges after vacation in this bench. This is the matter immediately after vacations.
second is concurrent. lordship.
Huh?
Second is concurrent.
Good.
Yeah.
Bad.
Lordship, in my opinion, it is good as because I am
Is it good like this?
as because it is concurrent. Then lordship.
No. Is it good like this? Like this or little less?
Lordship, after vacation.
You have a problem, your plaint is not horribly drafted.
Lordship, there.
You have not collected, there is no mention out there, you have collected, made it ready, you have not, you say that this defendant comes to you every time and thereafter he was willing, kneeling, and the word is willy-nilly.
No.
Willy-nilly, he comes out there and says that he does not sign any ER, then you issue the notice after in 2013. Ready with the amount would not do. There is a judgment of the Supreme Court categorical on this point. That merely because of that, why didn't you come? Because these suits for specific performance have to be done very early. Next.
I got information that petitioner died, lordship, but I could not contact the legal heir.
Who died?
Petitioner died, lordship.
When?
Lordship, that I am not very specific information, but I have information that he died. Lordship.
So if your lordship gives some time, and in the meantime, aviator was there, lordship, Mr. L. Mohan was representing respondent number 1. But other respondents, the office note says.
What are you challenging?
Lordship, in this case, there is a suit between respondent number 1 and pro forma respondent number 8 regarding some livelihood right, lordship. I was the pro forma defendant number 8. The suit proceeded ex parte against me, and in the suit, while deciding an issue, it was held that I am not the mutawali of that work of property. Against that, I have challenged. Lordship. So maybe
Why? Oh, this is under that wakaf.
work of it. So 83(9) proviso work of lordship.
But if he has died, how can you proceed?
Lordship, for that only, lordship, it may come in practice. I will take instruction from them.
Ms. So-and-so, the council submits that to her information, the petitioner had expired. It is seen that the petitioner right in the suit was personal to him, taking into account that it was a right of mutual, right to remain as a mutual. The learned counsel submits that she will ascertain with certainty as to whether the petitioner had died, as she had been only verbally informed. So list the matter after vacations on 11th of August. Dead person interim no date.
Obliged.
Half dead, half interim no date. Transfer petition. Where's the other side?
Other side was saying the service is not been completed.
Hello, let us have it after vacation. List the matter after vacation on 13th of August 2025. Interim order passed earlier shall continue till then. What is this?
Yes, the court had directed the petitioner to take steps on the respondent number 1 by dusty service. I had
Service?
by dusty service. Because
You've done?
No, I could not do because I contacted my client, but he has not reverted, and
Hello.
perhaps they are not interested. So I leave it to this honorable court to decide as to what is to be done.
It is seen that the service has not been effected upon the respondent in spite of due opportunity being granted to the petitioner. It is further seen that on 14/5/2025, this court had directed the petitioner to effect service by way of dusty. Then also the petitioner have not done anything. So considering the above, it is therefore, it seems that the petitioner has been delaying the proceedings by not effecting service upon the respondent on one hand, and also enjoying a stay to title suit number 677/2022. Accordingly, the stay order dated 2/8/2023 as well as 11/9/2023, which was extended by the order dated 11/9/2023, stands vacated, full stop. The learned trial court, that is the court of the civil judge, junior division, number 1, Kamrup Metro at Guwahati, is directed to proceed with the title suit, being title suit number 677/2022 in accordance with law. Full stop. The registry shall also intimate the learned trial court about the present order forthwith. Full stop. This court further directs. So it is further observed that the pendency of the instant proceedings shall not be a bar upon the learned trial court to proceed with the suit.
The action of this honorable court justice service had been taken upon 5 respondents, 3A, 3B, 3C, 4 and 5. But it seems they have refused to take service of notice, and I filed a justice service which is on record today.
Filing the written statement.
Yes, Your Honor.
Yes, Mr. Sharma. You are a plaintiff.
Yes, Lord.
You want to file the written statement. Service taken, Dusty.
Yes, Your Honor.
So on the 98.
How much delay?
No, no, so on the
Your
98.
Honor, there was no delay. On the 90th day, I have filed a petition regarding them on Order 7, Rule 11. So the honorable court has accepted my petition, kept the suit on abeyance, but has barred me from
Yes,
filing
yes.
this.
Your written statement is ready.
Your Honor, 10 days time, you can file it.
Subject to some cost.
What?
Subject to payment of sub cost.
Huh?
Subject to payment of sub cost.
The cost will be paid to the legal service authority,
sir.
not to you.
Yes.
Not cross the period of limitation also. Your Honor, I have filed this petition within the period of limitation. The cost,
On the 98. day,
Today morning I did it 30,000. 25,000, not 25. Of which 20,000 to them, 5,000 to the district legal service. The petitioner herein heard Mr. G. Kaushik, the learned counsel, appearing on behalf of the G. Kaushik
yes, sir.
for the petitioner, and Mr. R. Sharma, who appears on behalf of the respondent numbers 1, 2, 6, and 7. Ms. D. Kalari appears on behalf of the respondent number 9. Full stop. It is further this court have also perused the affidavit of service, wherefrom it is seen that the service upon the respondent numbers 3A, 3B, 3C, 4, and 5 was sought to be effected by way of dusty, but the said respondents refused to accept, taking into account the said that service upon the said respondents would be deemed to have been served. Full stop. The issue involved in the instant application is the order dated 29/7/2024, whereby the learned court of the Civil Judge Senior Division number 3, Kamrup Metro at Guwahati, had rejected the prayer to grant time for filing of the written statement on the ground that on the 98th day, the written statement was not filed. The learned counsel appearing on behalf of the petitioner further draws the attention of the court that on that very date, an application was filed under Order 7, Rule 11, read with Section 151 for rejection of the plaint, and the learned trial court, having registered the same, had kept the suit in abeyance till the disposal of the proceedings under Order 7, Rule 11, isn't it? The learned counsel therefore submitted that On the 90th day, as the suit was stayed by the learned trial court, the learned trial court ought not to have debarred the petitioner. Petitioners, how many petitioners? Two. The petitioners from filing the written statement. More so, when for the decision of an for deciding an application under Order 7, Rule 11, the settled principles of law stipulates that only the contents of the plaint are required to be looked into. This court have inquired as to the outcome of the application filed under Order 7, Rule 11 from the learned counsels, and it has been informed that the same is pending.
Yes, also. The present, as because the present by this honorable court has state the operation of this order, also, impugn order.
Is the
So,
Order 7, Rule
proceeding-
11 pending or
before the-
dispute?
Proceeding before the learned trial court is state also.
No, I'm asking you because this order was passed. I passed the order recently on 2/6, 28/3. 28/3. What happened? This was on 29/7.
I'm
Is
yet
the
to file-
Order 7, Rule 11 application pending?
I'm
pending.
yet to file written objection against that petition. Also.
Why? Why you have not filed? It's pending. First. In the opinion of this court, that the learned trial court, on one hand, keeping the suit pending, ought not to have debarred the plaintiff, the petitioners who are the defendants in the suit, from filing the written statement on the 90th day. First, the same appears to be, the same in the opinion appears to be an opinion was an error in exercise of jurisdiction. Accordingly, this court interferes with the order dated 29/7/2024 insofar as debarring the petitioners who are the defendant numbers
1 and 2.
1 and 2 from filing the written statement. First, Mr. So-and-so, the learned counsel submits that the written statement is ready and can be filed on any date as this court may deem fit. Full stop. Taking into account the above, any date fixed in the suit? No. Full stop. And full stop. Yeah. Taking into account the above, the present proceeding stands disposed of with the following observations and directions. The order dated 29/7/2024, passed in title suit number 107/2024, is interfered with insofar as staying so far as debarring the defendant numbers 1 and 2 oblique the petitioners herein from filing the written statement. Full stop. Number 2, the petitioners are given the liberty, the petitioner are given the liberty to file their written statement on full stop. This court grants the liberty to the petitioner to file their written statement. It is relevant to take note of that by an order dated 28/3/2025, the further proceedings of title suit number, where is it? By an order dated 12/2/2025, the further proceedings of title suit number 107/2024 was stayed. Full stop. The said stay order stands vacated. Full stop. The petitioners herein, both the parties who are duly represented are directed to appear before the learned trial court on 29th of August 2025. Full stop. On that date, The petitioners herein, who are the defendants number 1 and 2, is given a final opportunity to file their written statement. Full stop. The learned trial court is directed to accept the written statement, dehouse the fact that the suit proceedings is otherwise kept in abeyance till the disposal of the application under Order 6, Rule 17. The learned trial court thereupon shall proceed with the disposal of the suit. Shall proceed with the suit, shall proceed. As per in accordance with law. No cost. This is not a fit case for cost.
Order, it is mentioned, order 6 rule 17.
Order 7 Rule 11.
Order 7. The last part, it was mentioned in order 6 rule 17.
Order
Order
7. I've never said that. No, more question had been stayed in view of the filing of the application and the order. Dehouse the fact, like, isn't it? Dehouse the fact that the suit had been stayed and kept in abeyance pending disposal of the application under Order 7 Rule 11.
Obliged.
No. Transfer. Where's your friend? No friend. Okay. You have affected? File your affidavit of service? Oh, that day. Ah, yes. You affidavit of justice has not been received. Then, when did you file? I'm vacating the interim order. I remember you asked some junior of yours to come on the last occasion. We are vacating this type of interim orders. Where is the service? Then why it has not come? Why didn't you mention in the morning? It is seen that the service upon the respondent have not yet been effected. In spite of a further opportunity being granted to the petitioner. Considering the above, this court fixes the matter again on 11th of August 2025. Full stop. This court is therefore not inclined to extend the interim order.
On 18 Lordship, and we got the newspaper.
You have not filed it.
We have filed today, Lordship, because we got 2 days back. I have
It has been
filing-
submitted that the application affidavit pertaining to issuance of notice upon the respondent number 1 by way of paper publication have been filed today. To list the matter again after vacation,
File your-
along with the such affidavit.
Actually, the appeal is filed by that I have filed this for the condonation of delay, Lordship, in filing the cross-objection.
You paid the 25,000 in the cross objection. Why? You want the amount to be lessened?
Lesson, but, yes,
If you want the amount to be lessened, then you have to. If you are asking for whatever may be you see, the cross objection works in this field. That if in the case that some issues have been decided wrongly against you, but however, you are otherwise okay with the judgment, then in order to protect the judgment, you file the cross objection. And thereby challenge that portion of it so that the judgment is not interfered.
Like
But
clear
not on the ground that the quantum reduced. That is your case.
logic the balance because at because the deducted the pension amount, which is not correct. The court should not have deducted the whatever amount he was getting, the calculation ought to have been made on that account. But the court gave under conventional heads, the court gave something more. That only that reduction I want, but his appeal on that ground is correct.
And I is for what?
For condonation of delay of
846 days, my lord.
846
Huh?
days.
846 days delay,
But if,
846. Whereas the appellant,
No, but it's okay. But the question is, therefore, in that earlier appeal, I asked you, now, the question is just compensation.
so just a
When it is a question of just compensation, irrespective of whether the, the compensation which is to be given has to be just and fair compensation, not exorbitant compensation, not less compensation. Although it will have to be on the basis of, there might be exact formula you cannot have, but it has to be just and reasonable. Now, if the Supreme Court had given a certain amount as per which the conventional heads are to be worked out, the trial court or tribunal cannot give more than that on conventional heads. And if it has been given, this has to be, it cannot, it will interfere with the very principle under 168. Chalo?
that
Anyway, well, let us have it after vacation. Why should we? 846 days. But in my opinion, the question of filing an application for condonation of delay does not arise. There are
that's
many.
what
It is absolutely within the domain of the court. If you see Order 41, Rule 22. Anyways, today, why should I make him unhappy on the eve of the vacations? Allowing him.
I made the calculation, his compensation will increase.
my lord, why this 846 delay has to be accepted by this honorable court? Because they have contested the case before the trial court. And the respondent is well aware about it. Now it is the decision of your lordship to decide. I leave it to your lordship.
Okay. After vacation. After
Okay.
vacation.
Okay.
I will condone it. It's not a question of condoning. I'll accept it. We are sitting after 2, na?
Yes.
Well, 2, I'll pass the order at 2.
Fine.
I will accept it. And it is absolutely my jurisdiction to accept it, taking into account, and then to say direct the appeal to him. She's only challenging on the conventional heads, na? Nothing more than that. Chalo, we'll pass that order. Only problem was only for signing it, na? Pass so many orders. Tomorrow the courts are closing. That is the problem. Chalo, anyways. Courts are rising. Anyways, chalo. I'll let it come after vacation.
My lord, if your lordship pass the order, I'll be happy.
Okay, we'll pass the order. We'll take it up at 2.
Yes.
Okay, rest of the matters at 2. Anybody? Item number 13, what is there?
I am for the respondent, my lord. The second appeal again concurrence pending. During pendency of the second appeal, for the first time, my lord, the application IFL order 41, rule 27A regarding additional evidence.
It's
This is-
okay. They
the
can
2000
file.
2004 is title suit, my lord. The
No
2010
problem. It can be filed at any point of time. But we
the
are to
grounds.
consider this application
yes.
only at the time of hearing. Also, I ekhonot lekhokson. None appears on behalf of the applicant on call. To stop. Mr. So-and-so appears on behalf of the opposite
Solid.
party. To stop. This is an application filed under Order 41, Rule 27.
Lord.
for giving addition, for adducing additional evidence at the stage of the additional evidence. Full stop. Taking into account the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin reported in 2012 8 SCC page 144. 148, comma. The instant application will be taken up for consideration at the time of hearing of the application appeal. Full stop. Liberty is given to the respondents to file any objection in the meantime. 14. এখন থাকিব।
This is an application for readmission of appeal, Lordship.
I dismissed. How much time after? After how much time? 2010. Let this matter come up after vacation. Very good. I'm not going to do it because my philosophy is if I readmit, I hear it on that date. I don't have the time today. 2010, I am not going to allow it. I'll hear it and then do it. Then 23. 23 to come. Huh? Okay. List this matter appeal to the item number 14 to be listed on 16th July.
From the manner, they are doing the needful one. They are doing the needful one. Your lordship is already fixed the matter on 17/7. Let it be on that day.
I won't pass any orders now.
My lord.
Main repetition list the matter on 17/7/2025.
Only that copy may come in, suppose order will be passed today. You may be-
They will do the needful, they will give it.
Alright.
It had been a main, it has been submitted that the needful will be done by the concerned authority as submitted by Mr. G. Bush. This is the matter on 17/7/2025. Don't worry, it will be done. Mr. Bush has submitted and he will do it. If it is not there, I am there now on 2017. Don't worry. Your cross objection is only on that, no?
That other grounds are present because cannot. Ground C and D.
Huh?
Only my ground C and D for love and affection and for consortium and funeral. Only those two grounds. Lordship can mention that also.
Which
No
one?
other.
E?
No.
Only D.
Only C and D. For love and affection code A and for consortium, the amount given is more. Only on the two.
Only on C and D.
Yes.
System. Ekon likibo. Ekon I ekon likibo, huh? This is an application filed seeking condonation of delay in filing the application. In filing the cross objection to in the appeal being MAC appeal number 293/2017. This court have duly perused the provisions of Order 41, Rule 22 of the code And also the fact, and also the submission made by the learned counsel appearing on behalf of the petitioner, appellant, on behalf of the cross objector oblique the respondent number one, to the effect that the cross objection is only limited to ground number C and D to the cross objection, which is to the effect that the amount so awarded on the ground of love and affection, on the head of love and affection and loss of consortium, and funeral expenses, which are on conventional heads, cannot exceed to what have been settled by the Supreme Court, Constitution Bench of the Supreme Court in the case of National Insurance Company Limited versus Prannoy Sethi, reported in 2017, 16 SEC page 680. The learned counsel appearing on behalf of the objector oblique respondent number one submits that the cross objector oblique respondent number one would not insist upon all other grounds stated in the cross objection. Mr. I. Talukdar submits that if that is the only submission, he would not object. Considering the above, considering the scope of Order 41, Rule 22, which permits the court to accept the cross objection even beyond the period of 3 months, na? 3 months?
Within 1 month.
Within 1 month from the date fixed for hearing, comma, this court accepts the reasons so assigned in the instant application and permits the cross objection to be brought on record. First, the registry is directed to register the cross objection and tagged it along with MSC appeal number 293 oblique 2017. Full stop. Mr. I. Talukdar, the learned main MSC. Mr. Mr. I. Talukdar, the learned counsel appearing on behalf of the appellant submits that the appeal has been pending since 2017 and the matter requires an urgent disposal. Taking into account the above, list this appeal for hearing on 17th of July 2025, along with the cross objection. Simple question. The I dispose cross objection number hobo. Last order to Kali.
Hello.
Speaking of engagement of casual worker, master worker, I will have to see instruction. No such submission I have made in this case. In item number 23.
What is that?
The lordship has stated that there was a ban from the finance department. It has been now listed, but that statement
I have not stated anything.
instruction.
I have not stated. What has happened? What has happened is this. Something a very gross thing has happened, which he has brought to the attention. After I filed, writ petition has been filed and I have issued notice, he has released him. This is not done. So I think he said that he will take care of it, and I am fixing it on 17, and he will do that. So that you are not involved. We'll take care of your thing only on 17th.
Yes.
ex parte proceed contest. I'm sorry, Your Lordship. Opportunity of contesting the case, filing WS, not another. But in this case, I am also ready to pay the entire loan money.
Huh?
So, entire loan money, I am also ready to pay because loan money already paid and only the interest money is left. Paragraph 15 I have clearly stated. So I will be permitted to settle the matter to the tribunal. So opportunity will be because the learned tribunal is going to pass ex parte order against me. Although I am appearing, effect is only this, my lord. Two sets of advocates were engaged. No notice was served, my lord. No notice was served to me personally. Case procedure, ex parte, even then on the basis of newspaper publication only, I engaged two advocates. Advocate did not file opposition or written statement. So with the respondent petitioner here already, your lordship, filed petition, two petitions, my lord. That is also rejected, not allowed to contest anyway. So I will allowed to give an operation to my lord. 45, annexure 345. This was the ground, my lord. The learned tribunal held that there is no sufficient ground, but there is a reasonable ground. So I'm checking one.
What is the stage, Mr. Sharma?
Your Lordship, it is fixing for order, final order, judgment.
Final order only for
Evidence adduced.
proceeding expertise.
Your Lordship,
Evidence adduced.
No application, no evidence filed.
Your Lordship, nowadays the rules in the DRT has been changed. So along with the original application, we have to file our evidence on affidavit. And
Then?
defendant will appear and they will file their written statement and counter evidence on it.
Then
Then thereafter, original document disputes and acceptance and rejection of documents, thereafter hearing and thereafter judgment.
My lord,
no
notice
cross-examination.
Will be filed then only, otherwise not.
That is why, my lord, I may be allowed to cross-examine. There is nothing to pay. Claim 35 plus, more than 35.
The court has not allowed him to file a cross-examine.
There is no petition of cross-examination.
Just we file the petition.
Let us see the rules. What type of rules are these?
We may be allowed to contest, my lord.
This cannot be there.
Expert is going proceeding. Why I am contesting, I am interested to contest. Even I am ready to
What
pay
rules are these?
Yes, sir.
only loan money. Even, my lord, I am ready to pay the loan.
Mr. Then I am trying to help you out. Wait,
My lord.
let me hold the Mr. What type of rules are these? Let's also understand. Name rules. Debt recovery.
Recovery of Debts and Bankruptcy Act 1993.
Is it in the act?
No, it is in the rules and regulation. I think your lordship, regulation is not available.
Then what is this type of recovery?
That one decision Supreme Court regarding opportunity of contesting the case by filing a in exceptional cases can be allowed file contest the case filing WS, my lord.
Debt recovery tribunal rules 1993.
Yes, your lord. Procedural rules 1993.
Every application shall be accompanied by paper book containing statements showing the details of Iman, all documents, documents where the party endorsing a copy of the application to the filing of reply may file two sets containing the reply to the affidavit and shall endorse the tribunal may in its discretion expiry after the expiry of time. Normally it has to be filed within 1 month after the expiry of the period referred thereof. If the defendant fails to file the reply on so and so, may proceed forthwith to pass an order of on the application as it thinks fit. So this is as per order 8 rule 10. Where the defendant makes an admission of the full, this is as per order 9 rule 8. May at any time for sufficient order that any particular fact may be proved by affidavit or that the affidavit of any witness may be read as hearing on such conditions here. This is order 19, rule 2. If the defendant denies he is payable to hear, the tribunal may act upon the affidavit of the who is acquainted with the facts of the case also as the provisions contained in the date and place for hearing to shall notify the parties the date and place of hearing the application in such manner here. Order to be signed, publication of orders, fee to be here, working, sitting hours, edition and imam. Where is it?
There, but now I'm not remembering.
Don't make that the submission. Let him file his written statement.
No, your lordship.
File his written statement. What happens is going to fall. What? How can it be fixed for judgment?
My lord, I am trying to contest the case, even to late evidence or cross-examine. But
Matter was fixed for filing written statement come evidence on 28/11/2013. And when did you file that application? On 10/6.
page number 43. Page 43, annexer, my lord.
When was it filed?
Page 45.
Page
1524. Consideration and petition, page 50, my lord.
Page?
Page 50, annexer 4. Page 50. It was the negligence of the advocate, earlier advocate, my lord, two advocates, they did not file. We are interested to contest, my lord.
When did you file this application?
1/5/2023.
First of May. First of May.
And on,
And the order was passed on 27/2.
and your lordship, they have appeared on 28/11/2023.
Matter is as per previous order, I.S. Muzumdar has appeared on here. It is observed from the report that on Iman, learned proxy had appeared by filing Iman and sought for time for filing that we have was permitted. Matter was listed on so and today, but the written statement has not been filed by them and so on. Okay. Allowed it.
Lordship, that, I think that is not maintained.
Go to Supreme Court for that. Just see, yeah. 50,000 cost. 50,000 cost. This is an application filed. Heard Mr. B. Hussain, the learned counsel appearing on behalf of the petitioner. Mr. M. Sharma, the learned counsel appearing on behalf of the respondent number 1, nah? Respondent number 1. The petitioner herein have invoked the supervisory jurisdiction of this court, challenging the order dated 7/3/2025, whereby the application filed under Section 5 of the Limitation Act for condoning the delay in not filing the written statement on 27/2/2024 and further seeking permission to file the written statement was rejected. Full stop. This court had duly perused the Debt Recovery Tribunal Procedure Rules 1993, wherein the procedure for filing the application and have been stipulated in Rule 4 and 5. Pusto. Similarly, pusto. For the purpose of filing the written statement and other documents by the defendant, or filing a reply by the applicant to the written statement. Rule 12 of the Rules of 1993 stipulate the manner. It is seen from sub-rule 1 of Rule 12 that the defendant may, within a period of 30 days from the date of service of summons, file two sets, complete sets of written statement, including claim for set-off or counterclaim, if any, along with the documents in paper book form. Sub-rule 3 of Rule 12 further stipulates that if the defendant fails to file the written statement of his defense, including claim for set-off or counterclaim under sub-rule 1, within the period of 30 days, the presiding officer may, in exceptional cases and special serve, be recorded in writing, extend the period by such further period not exceeding 15 days. Sub-rule 7 stipulates, of Rule 12 stipulates, that if the defendant or the applicant, as the case may be, fails to file the reply as specified, in the foregoing sub-rules of Rule 12, the tribunal may proceed forthwith to pass an order on the application as it thinks fit. In the backdrop of this procedure stipulated in Rule 12, let this court duly take note of the order dated 27/2/2024. It appears from the said order that on 28/11/2023, the petitioner herein was represented by a counsel, by proxy counsel, by filing wakalatnama, petitioners, na?
Yes, sir.
And sought for time for filing written statement come evidence on affidavit, which was permitted. Thereupon, the matter was fixed on 11/1/2023 Full stop. 24. No order was passed. Uh, 24. When no written statement was filed by the petitioners. Again, when the matter was listed on 27/2/2024, the written statement cum evidence on affidavit was not filed by the defendants, by the petitioners. And it is under such circumstances, the right of the petitioners to submit the written statement cum affidavit was closed. This court further takes note of the reasons why the said written statement cum evidence was not filed as mentioned by the petitioners in the application seeking recall of the order dated 27/2/2024. A perusal of the said application reveals that the petitioners, there is one petitioner or how many? One.
Two petition, one condemnation, my lord. One petitioner, my lord, yes. Only one defendant, right.
Filed by the petitioner. Reveals that the petitioner had taken a loan of rupees 35 lakhs from the respondents, from the respondent herein, number one herein, on 13/4/2015, and he submitted that he would, and the said loan was repayable in 252 EMIs, that is 21 years till 2036. Upon receipt of the summons, sir, you call here survey summons?
That was not someone. Not some. I voluntarily here.
Upon receipt of the summons. No, upon coming to learn about the case on the basis of the paper publication, the petitioner herein appointed an advocate to defend his case, who appeared on 28/11/2023, and assured the petitioner that steps would be taken accordingly. The petitioner accordingly was assured, was under the assumption that the said council would take due steps. However, when the petitioner went to the respondent bank for making a one-time settlement, it was informed to the petitioner that the proceedings which was pending before the learned debt recovery tribunal was at the stage of hearing. First, upon coming to learn about the said, the petitioner made inquiry and come to learned that on 27/2/2024, the petitioner, along with two others, were debarred from filing their written statement. And it is under such circumstances, on 1st of May 2024, applications were filed for condonation of delay and for recalling the order dated 27/2/2024, thereby permitting the petitioner to file the written statement. First off, objections thereagainst was filed first, stating inter alia that the grounds which were stipulated were not sufficient and genuine grounds. First, the learned tribunal presiding officer of the learned presiding officer of the Debt Recovery Tribunal, Guwahati, on the basis of the written objection, came to an opinion, was of the opinion that the facts stated by the petitioner in the application for condonation of delay was concocted. The statements made in the application for condonation of delay was concocted, and accordingly rejected the application filed under Section 5 of the Limitation Act, as well as the application seeking recall of the order dated 27/2/2025 for, and it is under such circumstances the present proceedings have been filed. First, the learned counsel appearing on behalf of the petitioner submits that there was no fault on the part of the petitioner. Rather, the petitioner was taken for a ride by the counsel who represented the petitioner, who was entrusted to do the needful on behalf of the petitioner before the Learned Debt Recovery Tribunal. Further to that, he submitted that the petitioner herein is ready to settle the matter with the he's saying,
But there is no settlement.
his submission with the respondent number 1 bank. And as such, he should be permitted to. He's further further submits that the petitioner have a valid defense in the state proceedings. Admitted that the petitioner have a valid defense in the state proceedings. And on account of the fault of the counsel, the petitioner should not suffer. In addition to that, the learned counsel submitted on instructions that the petitioner is not adverse to having an out of court settlement in the matter. Isn't it, Mr. Hussain? Yes. Mr. M. Sharma, the learned counsel, appearing on behalf of the petitioner, a respondent number 1, questioned the very maintainability of the application on the grounds that an appeal lies against this order. Full stop.
Our court, there is a judgment.
And in that regard, which judgment?
CRP IO 80 of 2017.
What does he say?
Your Lordship, there is only that 227 can be available only on certain conditions. That is, if the tribunal is acting out of the jurisdiction.
That I will say. Submits that on the ground that there is an appellate remedy available. He further submitted that the facts which have been stated in the instant application, in the application filed seeking recall, the statements which have been made in the said application seeking recall are incorrect statements, and is nothing but a clever ruse played by the petitioner before the learned Debt Recovery Tribunal, as well as before this court. He therefore submitted that the present application is required to be dismissed. First, this court, having heard the learned counsels appearing on behalf of the petitioner, have given an anxious consideration to the matter. First, this court have further in detail perused the impugned order passed on 7/3/2025 in IA number 274/2024 and 275/2024. That is 24 only, na? 2000, yeah, both are 24.
Yes, Your Lord.
Full stop. It is seen from the impugned order the learned presiding officer did not discuss, but merely came to an opinion that what had been stated by the petitioner was a concocted story. There was no reasons also assigned in that regard. Let's go further. Upon perusal of Rule 12, duly takes note of 12, and more particularly sub-rule 7 duly takes note of that if the defendant in the said proceedings do not file the reply, the tribunal had the jurisdiction to proceed forthwith to pass an order on the application as it thinks fit. In the instant case, what the learned tribunal have done, as would appear from the order dated 27/2/2024, that the defendants were debarred from filing the written statement, come evidence on affidavit, and fixed the matter for hearing. This court inquired with the learned counsel appearing on behalf of the respondent number 1 as to whether there is no evidence which is required to be adduced on the said application. He submitted that the evidence on affidavit is required to be filed at the time of filing the application itself, which is the norm. And similarly, while filing the written statement, the affidavit of the witnesses is also to be simultaneously filed with the written statement. In that regard, he referred to what? He referred to Rule 12(6) insofar as the written statement of the defendant is concerned. court further inquired with the learned counsel as to whether the rules of 1993 do not permit cross-examination to the defendant of the applicant's witnesses if the proceedings is proceeding ex parte against the defendant. More so, when the proviso to sub-rule 9 of Rule 12 does not bar so. First, this aspect has been duly dealt with, taking into account that it is also the submission of the learned counsel appearing on behalf of the petitioner that the learned presiding officer, debt recovery tribunal, is proceeding with the disposal of the said proceedings, even without permitting filing of an application for cross-examination of the plaintiff of the applicant witnesses. This court, having perused the materials on record and taking into account the grounds and reasons stated therein, is of the opinion that as rules of as the learned trial court, as the learned presiding officer, have not assigned any reasons in the impugned order dated 7/3/2025 and have merely stated that the petitioner's case is concocted. And further taking into account the grounds and reasons stated therein, is of the opinion that as the rules of procedure are always subservient to the interest of justice, and right to file a defense is a substantive right, a further opportunity should be granted to the petitioner to file his written statement, come evidence or along with the witnesses, along with the affidavits of witnesses. First, this court, however, duly takes note of that the applicant, who is the respondent number 1, is also required to be compensated, taking into account that on account of these applications being filed, the respondent number 1 have been duly, the proceedings, the proceedings pending before the learned debt recovery tribunal have been delayed. First, accordingly, this court therefore disposes of the instant application with the following observations and directions. First, this court interferes with the order dated 7/3/2024, passed in IS number 274/2024 and IA number 275/2024, on the ground that the said order is without reasons. Number 2, this court further permits the applicant, the petitioner, who is the defendant number 1, in the OA number 283/2023, to submit his evidence, his written statement, along with the affidavit of witnesses on 23rd of July 2025. This court imposes a cost of rupees 50,000 upon the petitioner, who is the defendant number 1, in OA number 283/2023, which shall be deposited before the learned tribunal on the date of filing of the written statement come along with the affidavit of witnesses. Pustak. The deposit of rupees 50,000 shall be a condition precedent for acceptance of the written statement come so and so. Next, the applicant hearing, and the applicant oblique the respondent number 1 herein shall be at liberty to file application for withdrawal of the said amount of 50,000, and the learned tribunal shall pass appropriate orders. Kundu, 21, oh, Sabua. Can't help it then. You just stay. But that is illegal, na? Mr. Saikyo, what is this? You are Sabua.
My lord, I am for the private respondents who are also the decree.
No, understood. You are also decree holder?
Yes.
He is also decree holder? Then what is the problem?
They have prepared a plan of the building. Accordingly, my lord, the persons, the shop owners who were owning earlier, he has been allotted with a shop which has been newly built there.
That I know. Then?
So far as out of 27, 17 were given according. So far as I am concerned, I am entitled to shop number according to the position 63. And his position my lord, should be 24. Now I have been given initially for 71. Thereafter that has been cancelled. He has been given to 71. I have been given to 24. But this
But
shop,
this is an interstate dispute between you and him.
it is not a dispute. It is the
No. How can you go for disturbing his possession?
allocation, reallocation? There may be a reallocation by the Sabha Town Committee as has been given to the others. That is the only thing. It is not that he is not entitled to a shop. He is entitled to a shop. But I have to get the shop and he is also entitled to a shop according to his size and according to his place.
No, understood. But the question, if he is in possession, given the allotment, Sabha committee has to give it to somebody else, some other place to you.
But that is not the case. Must mention in the decree or as per the
No. Decree doesn't mention anything.
place. But it is given the size.
Decree mentions a particular, the decree categorically says who were actually in possession earlier.
Earlier.
That is what is there in the decree. Then they say that we are going to build.
Yes.
When they are going to build, they are going to give you particular shops. Now, where is it that the particular shops is to be given this?
They have,
That if it is done subsequent to the decree, that you have been given this or he has been given this becomes, and you have a dispute with that. It is an interstate dispute between both of you.
such manner, I am saying that he should be thrown out from the market complex itself. What I am saying, the as has been allotted to the other 17, because they have the plan now. The new constructed building, they have the plan, and each of the shopkeepers has been.
Chalo, we have it reopening now. Listed matter on 16th of July 2000 AR. Interim order passed earlier shall continue till then.
Can it 25th if not inconvenient?
Huh?
Can it be 25th? Inconvenient.
Okay, 25th. I am not taking up this bench.